He has no shame.
Liar.
No ethics. You have no ethics either, do you? Are you about to dismiss this?
No.
Okay, then set the court date and I'm leaving.
Set a trial date?
Yep.
What's the trial date?
I want to be heard on 2 matters.
You guys can talk amongst yourself when I'm gone. Because if you start the hearsay bullshit again, you're a tainted jury. So if he says anything other than anything about the case, you just tainted the jury. Because if the jury was sitting here, he wouldn't be able to talk hearsay.
You don't get a jury trial on this matter.
I don't what?
You don't get a jury trial.
You're the jury. You're supposed to be an impartial judge, which means an impartial jury. If you let this man spout off about anything other than the facts of the case, you just tainted the jury, You'll be recused like the last 4 judges. You'll have a commission of judicial conduct complaint. You'll have a lawsuit. You can laugh and joke all we want. This is an unethical piece of shit prosecutor.
911, what's your emergency?
No! You gotta do.
He's not lying. Watch as this unethical prosecutor gets completely destroyed at this hearing.
By a man representing himself who doesn't even possess a bar card.
And wore this to the hearing. Make sure you guys listen till the end. It only gets better.
This case has to do with Lane and several encounters he had at an O'Reilly Auto Parts store, where he would later be arrested.
Threatening to sue a judge and I threaten to throw fish in the water. So no.
I'm not threatening shit. I'm threatening to file a formal complaint on you because you're a piece of shit.
Fine, sir.
You're a fucking scam-ass judge over creating some bullshit.
Sir,
This is straight bullshit, and that's a lying sack of shit right there. Fake witness, wannabe victim.
Sit down. Thank you.
Play games. Put this clown on the stand.
Quiet, please.
Why the
Sir.
is this a pretrial?
Yes, it is.
Then why the are there witnesses here if I can't bring mine?
No one said you couldn't.
The fucking law says it, motherfucker. The fucking rules of procedure said at the fucking pretrial you can't bring witnesses. So why the fuck is she here? Because the state's a fucking unethical piece of shit manipulating this fucking court system. Because Romero's your fucking boss. Deloria's a dumbass. Where the fuck is the arresting officer? Why is this bitch here not the fucking arresting officer?
Sir, calm your language.
Why couldn't I bring the fucking witnesses?
Sir, please.
Where's my witnesses?
This is a pre-trial conference.
Then why the fuck are there witnesses
They're
here?
allowed to be here.
They're not.
Yes, they are.
No, they're not. Read the fucking rules, bro.
Are they the victim?
They're not the fucking victim, and if he pulls that shit, you're getting recused too.
Sit down. Are they the victim?
No.
I'm asking.
I got the fucking police report right here.
Are they the victims?
If you fucking lie, you already know what fucking time it is.
One of them is the victim.
Who's the victim? Neither one of them is a fucking victim. A victim of her own fucking stupidity, maybe. She's a witness, sir.
Sir.
Judge Riojas, that woman is listed in the police report as a witness, okay? This piece of shit hasn't turned over his fucking witness list and it's been 105 days. Where's the Rule 15 witness list? How the fuck are we gonna have trial if I haven't even received the witness list yet? Huh, Rojas? We have fucking 30, 40 fucking days to have the trial and I haven't even received, what? He's gonna call her as a witness? Why hasn't he disclosed that under Rule 15 2B, 1.1B? Where's my fucking witness list? Where's the state's disclosure? It was due fucking July 11th. Then Crenshaw said August 9th. Then Mayhew lost her fucking mind and didn't enforce it. Anything that this motherfucker didn't file by August 9th is not valid at trial. So if he didn't turn over a witness list by August 9th, there's no witnesses. And if you try to enforce some kangaroo bullshit, you'll be right up there with Crenshaw and Mayhew, right where the fuck they went. Time out.
Done?
There's nothing more to say. Set the trial date so I can leave so I can quit disrupting your court.
Sit down.
You let this motherfucker get off some bullshit, it's gonna be on you.
Fine.
The court must state specific reasons for continuing trial. Not just put a thing that says your trial's vacated, it's continued, that's not a specific reason. And when I fucking object to it, and she says, oh, you can't put the word bullshit in your order, so I'm objecting to it, or I'm striking it from the record. So my objection to my trial being vacated didn't get put out, didn't get, whatever you want to, litigated motion between us because she struck it from the record because my motion had the word bullshit. I've said fuck 50 times already today. Why did my motion get struck for bullshit? That's why she was my judge for 3 days. This piece of shit stands at the thing.
Sir.
All right, I'll stop. All right. I'll talk to you. So this unethical prosecutor stood in Judge Mayhew's courtroom after I got kicked out and literally talked into this microphone and said, Your Honor, I'd like to be heard for the record. We're getting the times, dates and times available for our witnesses. We'll let you know when you have trial. So how the fuck does he know his names and times of witnesses, but I haven't even received it? I'm the fucking fucking defendant, and it's been 100 days. So he's telling the court, I have my list of witnesses, and I'm saying, yeah, it was due 3 fucking months ago. So how does he have his list of witnesses? He's telling the court he has his list of witnesses, but the defendant doesn't have the list of witnesses. How can I prepare my trial? How can I interview this moron if you fucking don't give me their name and their information as required under by law, right? So, Rule 15.1b, the state has 30 days from request. I put in a motion to compel fucking law 4 fucking months ago. They had 30 days from that motion to give me their 15-1 disclosure, witness list, all that shit. Or by the first pretrial. That's the law, sir. You follow the law. The law said first pretrial, you must receive. I've turned over all my disclosure. They've had all my Rule 15 disclosure, all my witnesses, all my evidence, everything for 4 fucking months. I don't even have the witness list. But they're openly admitting on record that they've been interviewing witnesses, talking to witnesses to get their time available for trial. They're clearly communicating, but I don't have a witness list. How can I prepare? How do I know who's going to be called against me? Due fucking process. And I'm telling you right now, I got a federal lawsuit in a different county about judges that let this kangaroo bullshit done. And I'm telling you, you can read my lips. He will be under 2-year buyer suspension. Play games, and it's going to be you caught in the middle, sir. And it's not, and I'm not, this is how I got to talk, because this is my 5th fucking court date where nothing's happened by the law. So either today it's going to go by the law and you're going to dismiss this shit under Rule 8 and Rule 15 because my right, with prejudice, speedy trial rights, they have nothing. So how are we going to have a trial if they have no admissible evidence because they didn't turn it over by August 9th?
First of all, sir, can't dismiss the case once you file a motion.
I have, and they fucking threw it out for the word bullshit. That's fucking bullshit itself.
Have a seat, please.
Don't tell me you can't hear my motion to dismiss because it contains the word bullshit.
I did say that.
No, she did, and that's why we already had this hearing a couple weeks ago where I should have got my motion to dismiss granted based on everything I just told you, but instead she ended the hearing and let this man go in there and straight on this fucking microphone say, yeah, Your Honor, the state just wants to know, we're figuring out our witnesses, and when we get it to you, we'll let them know, right? It's literally on the minute entry, okay? So where the fuck is it? And then I sent him 7 emails since that hearing unreturned. Where's the witness? I call the fucking prosecutor every day. Where's the witness list? Where's the witness? Sir, how can you proceed over due process if I don't even have the procedural due process, right? Pre-deprivation, post-deprivation rights, right? So I have the opportunity to confront the witnesses before me, opportunity to be heard in an impartial trial, right? Okay, well, anything from impartial so far. When Cranshaw said, your deadline to turn in, the thing I'm arguing about right now, Cranshaw said he had till August 9th to turn that in. It's literally in your fucking minute entry that the state has till August 9th for disclosure. Well, we're here at fucking the end of September. Nothing. Not a fucking thing. It's literally in the minute entry from my July 11th pretrial when they set my September 30th trial. Why did Cranshaw, sir, if there's a conflict of interest, you declare that before the case, okay? Up until they got my wife fired, she was a law clerk for a federal judge across the street, right? They didn't even get her fired. She resigned, but you get what I'm saying. So the idea is you follow the law, okay? I know you work for the city. He works for the city. I'm not accusing you of that because I've only met you for 10 minutes. But I'm telling you what's been going on is, sir, how would you let a case move through arraignment, pretrial, set a trial, and then be like, oh, it's a conflict of interest, vacating the trial? Why the fuck didn't you declare it a conflict of interest before we started proceeding in the case? That's bad business. So they threw it to Mayhew, and then she wouldn't let me talk. She let this man stand in there and lie right into the fucking microphone. It's all over my YouTube. The whole world has seen this piece of shit. Sorry. This unethical prosecutor can do everything he's doing, and we know why he's doing it, because I'm suing the cop that did it, and that's her little buddy. She's an undercover informant for the Tucson police,
Your Honor,
and her mommy the cops.
To stop making a record directing anything to the victim, calling the victim.
Witness. You bring the witness. You get. Hey.
Sir.
All right. Okay. Go ahead.
She's the victim.
Okay. If he's saying she's the victim. He just lied to you right to your face, sir. I can show you the police report where it says Mackenzie O'Brien, witness. So twisting this shit where she's the victim is their only hope, because then they won't give me a pre-trial interview because they're saying, and this is why Cranshaw got off the case, because we came in the thing, he said she's a victim. She's not. It's literally, sir, you have the police report, read it.
I don't have it.
Well, then how do you not have it when I've turned it in my motions? That's what I'm saying, sir. You don't have the police report? Then how are we standing here letting him call her a victim when the police report that I was given by the prosecutor lists her as a witness?
He's allowed to claim whoever someone's a victim.
Oh, okay. Well, I'm a victim now. Well, okay. So let me say this, sir. I'll allow you to say that he has the burden's on him to argue all that, right? Okay. So now the burden's on me to show you something. This victim right here. So this incident took place May 20th. Okay. On July 30th, she was posting on her own YouTube channel talking about the case. So how can the victim talk about the case, but I can't talk to her, right? I'm not allowed to contact her, but she's allowed to go on her YouTube and say, Lane's lying. It looks really bad. I know you got videos of me lying, but I promise you I have a video that shows Lane. Sir.
At a trial, when there's a trial, you have the right to present that evidence.
There's not going to be a trial because you're about to dismiss this.
No, I'm not.
Okay, then you're going to recuse yourself.
I'm not going to. Why would I recuse myself? What?
I'll file the motion. Don't worry.
All right, now.
You'll see.
State, which is the next state?
Yeah, my turn, Your Honor. First thing the state's going to ask for is a motion to modify the conditions of release. All these requests are going to be directly stemming from the case. They're not going to impact Mr. Myers' ability to defend the case in any way. Mr. Myers has taken the information the state has provided under Rule 15 and posted on the internet. That's a violation of Rule 15.4.
Oh, sir, objection. We're not fucking having.
Sir, he didn't interrupt you. You don't interrupt him.
You better fucking hold the law.
Sit down.
A violation's a violation.
I said sit down. You'll have a chance.
He don't get to stand over there and cry victim.
Sir,
He's the fucking state of Arizona and the burden of proof's on him.
Right.
Give me the fucking witness list. You want to sit over there and talk shit about what I violated?
Sir.
Guess what? I didn't post shit until he violated the August 9th rule.
Sir.
So if you don't follow the rules, you don't get to enforce them.
Sir, you're toying dangerously.
I get it. I feel you, sir. I feel you, sir. It's nothing personal. It's nothing personal. It's nothing personal. It's nothing personal. It's fucking business, man. It's business. This is my fourth judge. This is 106 days. 106 days into the case. You only have 180.
Included time. When you file a motion to continue.
I did not file. This is the bullshit, sir. There's no fucking motion filed by me to continue, and that's the bullshit Cranshaw tried to pull. The last judge tried to pull. I did not file a fucking motion to continue anything. I filed one before my 11th pretrial. I then withdrew that motion. It was ruled on, withdrew. I showed up at the fucking hearing. Cranshaw wrote that shit on there. I filed a motion showing that wasn't true. They didn't fucking hear it because it said bullshit. You better not, sir. You better not come in here and state into that fucking microphone that I filed something to continue my trial. That will be the misconduct commission complaint that you can't fucking read. I did not continue shit. Pull the fucking motion out where I asked to continue my trial. Every fucking day in this case is included. Don't pull that bullshit. I don't give a fuck what you got to say. Look at the record. Read the fucking thing. It says that I filed a motion. Show me the fucking motion where I continued my trial. Show me it. Pull it out. It's in the file. Pull it out. Walker, pull it out, bro. Pull it out. Pull out the fucking motion that I filed to continue the trial. But that's what I'm saying, sir. You don't get to make the law up. You get to follow it. I just read you why you're breaking the law and you look me dead in the face. And
Mr. Walker speak, and you'll have your chance.
he's not allowed to sit here and talk bullshit. Everything I've said it might be loud, it might be obnoxious, but it's legally based. He's trying to bias the jury. You just sat here and looked me dead in the face, sir, and said that time included. Oh, you obviously haven't done your research on this case. Clearly haven't read the record. You're just going off the fucking surface level bullshit. You saw something in there. Just because Cranshaw claims I filed a continuance to cover his ass, that doesn't mean I filed the continuance. Walker didn't file a continuance. Neither one of us moved to continue the trial date. I have emails from him stating he doesn't know why it was granted. He didn't move to continue. He agrees with me. It should not be continued. So I could show you an email from the state saying he wanted this.
So we can just move on. I agree that Mr. Myers has never filed a motion to continue. So can we just move on past this?
So we could just move on past the fact that the law says if no motion to continue is filed, you have to dismiss with prejudice, because unless you do it with if neither one of us moves, the only way you could do it is something signed by the Arizona Supreme Court Chief Justice saying you're suspending Rule 8. Right. Neither one of us said this. You just said time included. There's no suspension of Rule 8 here. Every fucking day, second time since I've been falsely arrested is counted in this case. Where's the fucking arresting officer? Sir, so right now you need to tell him he needs to produce the officer for an interview. They won't fucking give me the officer that arrested me on the side of the road, put me in the cop car for an hour and a half. They will not make him available for a pretrial interview. We know he's not the victim, other than a victim of his own stupidity for arresting me and getting himself into this. Where's the fucking witness? So 105 days in, they won't give me the witness list. They won't produce the arresting officer. They're lying to you about the case being continued. You don't have time to have a fair trial. We're at day 106. You have till day 180. That's tactical advantages. I've read all the Supreme Court case law. They're doing this to gain a tactical advantage that gives you the power to dismiss it with prejudice. I can show you the fucking case law just like I did in my motion. See, I'm arguing from the Supreme Court. He's arguing from his feelings. The Supreme Court of Arizona, sir, is ultimately going to be the arbiter of your decisions. And that's what I'm telling you. You better think twice before you violate Lane Myers. And that's not a threat, sir. I'm going to apply the law to you just like you. So this case is, I'm charged with 2 counts or whatever for her lying bullshit. Well, he thinks that I'm being prosecuted for whatever this charge is. And I'm standing here saying, all I see on this ticket is, and the judge's career, and the prosecutor's career, and the officer's career. So there's a conflict of interest with all of us right now. Because it's not even a conflict of interest, though. It's a conflict of intent. The intent by this prosecutor is to get off some charges to prevent the officer being sued from unlawfully arresting me. Otherwise, why wouldn't he make the officer available? Why haven't I been able to question my accuser? Why did the man that held me in handcuffs, sir, and the most disturbing part is, while being in handcuffs on the side of the road for an hour and a half, the cop looked me dead in the fucking face, and you're going to see this on his body cam, and he said, a jury's just 12 people too stupid to get out of jury duty. And you're right. The judge might dismiss this case, but you got to deal with me fucking with you tonight. This fucking cop said that on the body cam, for the whole world to see, and he's worried about me releasing it because it looks fucking bad, because before he came and arrested me, Your Honor, he put this woman in handcuffs because she asked him to. The victim was playing BDSM in the parking lot with the cop saying, Sir, he walked up. I feel you. I won't use that. I got
This is enough.
Hey, no, he let her handcuff her. She got the she got to read the police department laptop. Watch the video, sir. Watch the video. I'm not taking it down either. The whole world needs to see what happened to this. The whole world needs to see what happened. She asked the cop to arrest her. They sat there for 45 minutes. The cop said he could beat her. No, dude, there's no trial. You're about to dismiss this case. Okay, well, there won't be no trial with you then.
My turn, Your Honor.
To lie.
Back to what I was saying. Under 15.4D, none of this material is supposed to be disseminated.
He's talking about the police report and the body cam. See how he's saying material? Police reports and body cam. Police reports and body cam. Police reports. Thank you.
You will not interrupt him.
Thank you.
Go on.
Material that's provided under Rule 15, like the body worn camera and the police reports, is not to be made public. So on that basis, Mr. Myers has violated Rule 15. The videos need to be removed from YouTube, number 1.
They're not coming down.
Number 2,
Ever.
if they don't come down, the state is going to ask the court that you hold him in contempt.
And I'll do it. Pay. How much do I owe? The videos are not coming down, sir, ever.
Second thing is...
It's my First Amendment right. And no, hold on. Objection. I know. Let me peacefully... All right. Let me peacefully... I have an objection to what he just said. Let me peacefully make my objection, sir.
Please, can we move on?
No. He just said that... Hold on. Time out. No, sir. I have the opportunity to be heard.
You did when he's done.
No.
When he's done.
Directly to what he just said.
He's done.
I'm objecting what he just said. I want to put an objection on the record to the first thing he just said. Okay. He said that I was releasing body cams and body worn camera and police reports that they provided. That's wrong. I got it from a public record request from Chris Avey, city attorney. So anything I get from a public record request, I can put on my YouTube channel. Now it might be the same material that's in their disclosure, but we could go to court. Charge me with contempt. I'll show you the public record request. You can see a video on my YouTube of me giving the public record request to Chris Avey, and Chris Avey going, here, take a picture of me. Chris Avey stands on my thing and goes, look, I got your public record request. So he's lying again. He's lying. He just said I should be held in contempt for releasing a public record received under a public records request. He's lying. He's attempting to manipulate because I sound crazy and all that. He's trying to be the voice of reason. He's the voice of lies.
Okay. Continue.
Number 1,
He gets to tell you what you need to do.
Go on. He's asking. You tell me. He's asking.
I'm requesting to modify Mr. Myers' conditions of release accordingly. Number two, Mr. Myers needs to be directed not to have any direct contact with judges, court staff, city prosecutor staff, or other city employees. If he wants to do something on a case, he can file a motion through the appropriate
He just
channels.
asked you, objection,
Sit down, sit down.
objection, public officials. I can contact public officials at any time. Every person he just said is a public employee. You will not take away my rights.
Sit down, please.
Every person he said, though, was public record, public official.
Go on.
And these are people that Mr. Myers has been harassing and calling cunts, among other things, Your Honor.
Objection, irrelevant, man. What the fuck does that got to do with what I did on May 20th? Who I called a cunt? He's taint. That's irrelevant. You're allowing him to prejudice the jury, sir. You're supposed to be impartial. That means that if the jury was sitting here, you wouldn't allow him to say that I called it a public employee a cunt. That has nothing to do with this case. So you have to act the same as if the jury was sitting there, sir. That's how you have to be at all times, an impartial jury.
Let me ask you this question. How do I know what he's going to say until he says it?
Who? Ahead of time. Ahead of time.
How would I know ahead of time?
Ahead of time what he's going to say.
How would I know ahead of time he's going to say what he's going to say?
But now that he said it, why didn't you say that's irrelevant? Why didn't you say that has nothing to do with his guilt or innocence on May 20th?
It had nothing to do with-
Then why the fuck? That's the third case courtroom I've been in where he talked about me calling him cunts. Hey, cunt is free speech. Whatever. So
But it's not polite speech.
I don't care if it's polite.
In this courtroom, you be acting.
I understand. Don't call nobody in here. But I'm saying, he's saying that in my communications with public officials, I've called them that, right? That word, right? That's my right. Okay? And it has nothing to do with whether I'm guilty or innocent with what happened at O'Reilly Auto Parts on May 20th.
I agree.
So why is he, do you understand? Why is he talking about it?
Quiet, quiet. Let him finish. Go on.
Your Honor, the court can impose, modify conditions of release for the protection of anyone in the community, and of course have wide discretion to do that. It is not onerous to ask Mr. Myers not to call court staff or not public officials.
Take away my rights is onerous.
Okay. Number three.
You're a bro. Your wife's a
Sir.
Your Honor, I'd ask Mr. Myers to be held in contempt.
I'll pay the fine. You're a your wife's a how much is the fine?
I'll poke you.
Well, you think jail? So now you definitely are removed from the case because you just threatened me with jail, just like Cranshaw did. And look what happened when Cranshaw threatened to throw me in jail.
Number three.
Put me in jail for saying it. I dare you.
The state will respond to any substantive motion filed that is not stricken by the court.
How can my motion be suspended? Here's my motion. Permission to approach. Here's my motion. Permission to approach, sir.
Please finish your
Let him finish. If you have a chance to say, please done. Go on.
no contact with non-court prosecutor, people who are not related to this case, such as immediate family.
His wife's a public official. His wife is a public employee. Don't let him gaslight us.
Like the voicemail Mr. Myers left for my wife saying he...
Yeah, and I'm gonna keep sending her fucking emails and calling her because she's a public official.
And the email that he sent to me saying he was gonna come pay my wife a visit and then come...
Now he's lying. Here, sir, I'm gonna show you permission to approach. I got the email right here. I said I'm gonna go knock on his neighbor's doors and ask him if they want to vote for Trump. That's what I said. So he's twisting the narrative. He's a squeamy little bitch. I'm telling you, man. I'm telling you, dude, you're letting this fucking prosecutor embarrass the entire profession. You and this prosecutor are embarrassing the entire legal profession right now. Unless you're about to dismiss this for all his games. He can't make a serious argument. Oh, the police said this is what happened. Nothing. It's, oh, he called him a oh, he emailed my wife who's a public official. Oh, he said he's gonna come put a billboard sign for Trump next to my neighbor. I didn't say I'm coming to his house. I said I'm gonna go to his neighbor's house. It's fucking public record. He's a public official. It's public record. You can type Matt Walker in Google. You'll know exactly where he lives. He's a public official. He has a less expectation of privacy than a private citizen. I've checked all the laws for residential picketing. I'm not breaking the law, so why is he bringing it up? I'm hurting his feelings. Fuck his wife. She's a public official, whatever. I can talk to public officials as long as I don't threaten them. I can go. I went and stood in front of Laura Conover's house. She didn't tell the fucking judge. Oh, he came in front of my house. He called me. I call Laura Conover every day. Why can't you just stand on business, bro? You've been here 20 some years, dude. I know we both know whose interests you're protecting, but I'm not accusing you of impropriety yet. But if you just told me I would go to jail for saying protected speech, yeah, you could say it. But you actually have to have a trial for contempt. And you can't issue contempt in the same hearing that the contempt takes. So like, You just literally threatened to put me in jail, knowing that you can't even do nothing about my contempt. You have to issue an order to show cause for contempt. So how the fuck are you gonna put me, you know what I'm saying? So you just attempted to manipulate your power against me by saying, I'll lock you up. You can't, you can show it, or now you can issue an order to show cause, sure. And then we can have a hearing about my contempt. And then if I'm found to be in contempt, if it's criminal contempt and you want to try fine over $300, criminal contempt doesn't carry jail. It's a civil infraction. It's not a crime. You can't be taken to jail for contempt. You can be detained while a show cause order is issued. You are not going to weaponize the court either, sir. He's not gonna, and you're not gonna.
Any further, Mr. Walker?
Sure, Your Honor. These conditions that the state is requesting have absolutely no bearing on Mr. Meyer's ability to defend the case. They have no bearing on his ability to do anything. The state would like nothing more than to simply proceed with this case without Mr.
Then why don't they give me the fucking witness list? It's 105 days. They want to proceed with the case? Give me the fucking witness list. Give me the arresting officer. You can't proceed with the case? They're sitting here saying, oh, he put the videos up. You hurt our feelings. You said you were going to protest in front of my house. My legal right. You're going to exercise your legal rights while we violate your rights and hold the witness list and hold all this. He wants to modify the conditions so I can't contact public officials. Oh, he's got the public records up on there. But he hasn't turned over anything. Every single fucking piece of disclosure under Rule 15 that I'm required to give, I've given. They've given none. None. None.
File a motion.
I did file fucking 10 motions and she lost her shit just like you're doing it, bro. I'm telling you, I can see.
All disclosure available.
Next time, objection. So you made your witness list.
Mr. Myers, sit down.
Tell him to
Sit down. You have a chance
tell him to state for the record. Where's the witness list?
You'll have a chance to respond.
If he's made the witness,
You'll have a chance to respond when he's done. Okay? I'm not preventing you to speak. Just have kind of be orderly. Okay.
As far as the interviews of the officers, Your Honor, the state was prepared to set those until Mr. Meyer's conduct made that impractical. The state thinks that what would probably be best is if we simply have an evidentiary hearing, but the state is requesting that Mr. Meyer's release conditions be modified.
Well, in terms of him contacting, you can't contact the victim, clearly.
and I have it.
Actually, he has, Your Honor, but that's fine.
Put it on the record. Tell him how I could have contacted the victim. Put it on the record. No, you can't just say that I've contacted the victim and not explore it further. You can't allow me to contact the victim either. So if he just said I contacted the victim, put it on the record. I know I can't contact the victim. He just accused me of contacting the victim, so put it on the record. He just said it, sir. The whole world can hear him say, actually, he did contact the victim. So now he needs to articulate how I contacted the victim for the record so that the only thing that's not on the record is, actually, he did, sir. He needs to articulate his position like a lawyer. He just accused me of contacting the victim, sir. That's a violation, right? If I contact the victim, that'd be a problem, wouldn't it?
If he decides to charge you for that.
If who decides to charge me? He doesn't get to decide shit about contacting the victim. He's asking you about me contacting the victim. If I
was asking me to tell you not to contact him.
No, he's saying that actually I already did. He just accused me of contacting the victim to twist the narrative. I'm demanding he articulate when and where I contacted the victim for future reference on the record. Just like an evidentiary hearing, all that shit. I have the right. You need to order him to articulate how I contacted the victim if he's gonna make those allegations into this microphone.
You can request to make them, but I don't have to follow your request.
You're saying I can request that you make him articulate it? All right, well, hey, so objection on the record.
It's all being recorded, it's on the record.
Oh, it's being broadcast live.
Okay, so you're suggesting an evidentiary hearing as opposed to
witness interviews.
Take up the court's time. Take up the court's time because grown-ass men can't have an interview. You fucking arrested me and held me back in the cop car for an hour and a half and said a jury's just 12 people too dumb to get out of jury duty. Don't give me this he's scared shit. I'll go to the police station. Put 50 fucking cops in a room and I'll go interview this cop in a room. It's bullshit. Why are we at day 105?
Do you object an evidentiary hearing as opposed to an interview?
Oh, we're going to have that too, though. So then I get you're not going to deny me due process. I get the pretrial. Okay, the only reason I haven't filed the suppressed to get the thing, because I'm trying to get my civil lawsuit. I need that deposition because I'm going to be suing him after. And right now I can use the power of the criminal court. So I let him accuse me. Now I have power if the judge doesn't go off script and go off the law. So what I'm saying is I have the right to a pretrial interview. Okay, I take that interview. Then we have an evidentiary hearing. We come to that evidentiary hearing under oath, and then I can ask him questions I already asked him in the pretrial interview, and then ask him it again, and if he changes his story, I can say, I want to perjure the witness, I want to show you this, where in the pretrial interview he said this, and then once he knew all my questions I was going to ask him at the hearing under oath, he changed his answer, okay, because the pretrial, I do this for a living. I have lawsuits in multiple states. You can watch I know you can't, but I have a whole YouTube channel deposing cops. This cop will be deposed by me in a pretrial interview before a hearing. This is my right. I am accused of a crime. I get the full remedy available at my defense. Everything authorized under the Arizona rules of criminal procedure, I'm allowed to enact. I've asked for the cop's interview many times. There's no reason that a armed police officer who claimed to her that he could beat up 46 people and he only came there to beat me up and leave. The arresting officer said to his body cam, to her, he only came there, I was coming here to beat him up and leave. He literally says that, dude. And then he says, well, you're right. The judge is probably going to throw this out, but I get to fuck with you tonight. And then he said, and I said, well, I'm just going to show the jury the body cam. And he said, no, you're not, because the jury's just 12 people too dumb to get out of jury duty.
Okay, Your Honor, can we move on?
No, we can't.
Okay, can we move on, please, Your Honor? Thank you. Okay.
Why does he want to move on?
There's no chance that an interview is going to be productive with Mr. Myers?
No chance.
Police officers?
No chance.
I think it's better to just do an evidentiary.
He thinks that my rights should be violated. I should take away my right of free speech.
Can you please exercise some control here and please stop?
Can you exercise some control and stop lying?
Mr. Myers, sit down.
This judge is doing a great job of handling this. You're the one that's standing here lying and inflaming the situation with every lie.
Mr. Myers?
Every time he lies, I get mad, right? It's pretty obvious. Every time he lies, I get mad. Every time he doesn't lie, I don't get mad.
Control yourself.
I got it. I'm in control. Oh, trust me, I'm controlling myself. You know what I'm saying?
If the court wants to order a deposition of the officers under Rule 15.3, that's within the court's prerogative. I think an evidentiary hearing would be best.
Well, I already filed the motion for that, but they won't rule on my motion to produce the officer. I filed it months ago. Okay, I'm following the procedures. I filed the Rule 15 motion because I tried for weeks and months to get the interview. Then I filed the motion to compel the interview. And this man hasn't responded to one of my filings in months. Months. How can we litigate? If I was a defense attorney, the state wouldn't ignore him. It's because it's me and they know what's going to happen. If the interview's so bad, it's going to make me look bad, right? So if giving me a pretrial interview is unproductive, well, the state should want that then because we're going to have the interview and it's going to make me look bad. So if I'm the problem with the interview, then let's schedule the interview. And if I go off, if I'm disorderly or you know what I mean? If I violate any rules during the interview, or you get what I'm saying? They just end the interview. The person being interviewed has the right to end the interview if you're not following the rules of the pretrial interviews. So why am I not given a chance to get a pretrial interview, follow the rules of pretrial interview, and then you can decide, you're prejudging me. That's the definition of prejudice. This is a tactical advantage. They don't want me to interview the cop because I'm going to get to prepare for trial. And then when I got him under oath at trial, I'm going to get to hit him with all his lies. And then I'm going to perjure him. But instead, they want to hide the cop till trial. You've been here 25 years. They want to hide the cop at trial. I smell shit, right? I smell poop. You've been here, bro. You know how the game works.
Okay. I'll go ahead and order a deposition.
Thank you.
When would you need a deadline? I'll set a deposition.
Thank you, sir. In person or what? I want to do it at the police station, in person. They can have 10 cops sitting there, and I'm recording it because it's my right, and I'm going to provide him a copy if he doesn't come. I know because this started out with me. Sir, do you get what I'm saying? I've already filed everything I'm required to file. We could have trial today, and I've made all my Rule 15 disclosures available. Supplemental disclosure, initial disclosure, witness list, evidence, like electronic evidence. They have a Google Drive with all my evidence, and I have nothing of theirs.
What conditions is the court attaching to the interview or the deposition?
Conditions?
What conditions do you think are? I'll ask you first and then I'll ask you, okay? What conditions?
Again, Your Honor, I don't think abusive, profane language, I don't think being able to go in there and accuse the officers of sexual conduct of people in the case is going to be an appropriate topic for a deposition. So what conditions is the court attaching?
It's too hard for me to predict.
Thank you, sir.
I can't, at this point in time.
It's up to me if
Until it does something, I can't.
It's kind of like pornography. You know it when you see it. You know what I mean?
So what I'm going to order is that a deposition occur no later than October 11th. Does that work?
Sure.
We only have till November 14th to do trial. So, I mean, you're going to give me a deposition. That's supposed to be enough time for me to prepare my thing. We're going to have an evidentiary hearing. We're going to have a motion, unless we have the motion to dismiss and the evidentiary hearing all in one. And then they still have to give me 20 days ahead. How are we? Okay, so hear me out. You just ordered a deposition of the arresting officer. I still don't have the witness list. How are we going to have an evidentiary hearing or whatever when I can't even prepare for it? I don't even know who to call the evidentiary hearing.
Are there any witnesses other than those disclosed in the police reports?
No, Your Honor. The state has disclosed all witnesses, all police reports.
He has not given me, sir, I'm going to show you what permission to approach. I want to show you something. Here, sir, permission to approach. This is what I'm saying they haven't given, right? A rule where he can say he did it, but you have to file it like I did. You have to file with the court that you disclosed. He could say all the witnesses have been disclosed, so what he's falling back on now? Well, then how come when he was at the hearing with Mayhew, he spoke into this microphone and said, we're not sure who the witnesses we're going to use are. We're still preparing all that and getting their schedules.
Now he said the witnesses are in the police report.
They're all there, Your Honor.
At 105 days in so you're calling every witness in the police report?
You know, the potential witnesses.
Well, there's like 15 people. So is he calling, he needs to articulate on the record.
He can listen to as many witnesses as he wants.
He hasn't listened, no, he has to listen to a motion. Sir, he has to listen in a motion. Not, he can't just say, so, speak their name, I need something, not the police report. I'm too dumb to read the police report and figure out who's a victim. Well, sir, listen. He's saying, go by the police report. Well, on the police report, she's listed as a witness. Now he's calling her a victim, so if we go by the police report, then she's a witness and I need to interview her too. You need to order her deposition too. Because if I'm going by the police report and that's their witness list, she's a witness list. If he wants to produce and file a witness list that has her as a victim and other witnesses' name, that's how Rule 15 disclosures work.
Are you designated a witness?
She's a victim, Your Honor.
A victim? He's designated in court.
I can produce a witness list by the end of the day, Your Honor. That's no problem.
He can produce a witness list by the end of the day, but not in 105 days. You see what's happening here, sir? I appreciate you, sir. I appreciate you being a man of honor.
All this stuff is on the record.
I appreciate it, sir.
Necessary down the line, you have the record for if an appeal is necessary.
Oh, appeal will be, we already know, if you don't dismiss it today, we already know where this is going.
So
is that an order? They're going to produce it by the end of today, September 18th, 2024. I'm going to have the state's official witness list produced under Rule 15. That was supposed to be produced by August 9th under court order. They violated the court order. Can you sanction them for violating Judge Cranshaw's disclosure order? So if you look, you said, sir, I want to set some precedent for this thing moving forward because now it's, right? So you're saying you just gave them till that day to produce a deposition, right? And if they don't, the burden's on me to file the motion to compel and play games, right? So they haven't followed the rules, right? And I've been requesting officially their witness list, right? Just like the thing. You had to order them to give me the deposition, right? And now here today, he's saying I can have the witness list by the end of the day, right? Well, why couldn't he have it by August 9th? If the witnesses were just the people in the original police report from May 26th, then at some point he should have said in the record, Your Honor, the witness list is the people in the police report. But he didn't say that till today, 106 days in, now did he?
You have these objections and concerns about how he's handling his witness list.
Yep, and that's why I'm going to his neighbors with a Trump sign and asking them if they want to vote for Trump. And that's why I'm calling his wife names, because she works at the school, which is my right. She's a public. If you take your paycheck from the public, then I can call your wife, I can email her. Now I can't talk about the case, which I didn't. I said I asked her if I could come down there and get a special help.
What's happening with his wife is irrelevant to this matter.
That's what I thought too.
If any witness other than the victim has issues with them, they have the right to file for an injunction.
So you'll not be modifying the conditions of release, Your Honor, to be clear?
At this point in time, just be careful, Mr. Myers.
I know. Hey, trust me, that's my middle name.
Okay.
Walk the line. Lane, walk the line, Myers.
Okay. If any person...
I get it.
Okay.
I haven't been... You notice that it's just baseless accusations. It's not anything that they want to put on the record where we just literally had an argument where they're saying I'm contacting the victim. Well, they won't put it on the record.
If those people feel that you're contacting them...
Who's them people? The witnesses? Well, okay, wait, hold on.
Wait a second. Your name?
Mackenzie.
You want him to contact you?
No, sir.
Okay, so you've been put on notice.
Okay.
You're not to contact him.
Now I'm going to ask you something. Is she allowed to contact me?
You have just... No. You don't want her to contact you?
No.
Okay, don't contact her.
So why isn't she being in trouble for contacting me when the last judge said that we can't contact each other, and then she started posting on this woman right here came on my YouTube channel making comments as the victim.
Doesn't she have a First Amendment right like you?
No, because she's contacting the defendant and she's the victim. Wait a second, sir. A First Amendment right to contact the defendant?
Yeah, nothing wrong with that. The laws do not prevent some contact. The way you're...
So I'm not allowed to, the defendant is not allowed to contact the victim.
Correct.
But the victim's allowed to contact the defendant? No, they're not.
Well, the Arizona Constitution, victims' rights.
The victim has the right to harass the defendant?
You have the right to file an injunction against...
I don't need to file an injunction. I want her to keep doing it so I can use it against her because she's too stupid.
That's your right.
Why would I block her from her own stupidity? She's digging her own grave and the state's grave.
Okay. You're not to contact that witness. She's...
Well, okay, wait, hold on now. If you read the police report, we got to get, okay, you're calling her the victim, right?
Who's the victim?
Right here. That woman has nothing to do with it. That's her babysitter.
So you're not to contact
Her, Mackenzie O'Brien,
You're not
right?
to contact her.
Okay, so let's go over this, sir. When he said he's going to produce the state's witness list, right? The police report lists her as a witness, right? She's the one that called 911. She's the one that was interviewed by the cop. She was the one that accused me of what happened, okay? She's the one that has this alleged video of me breaking the window down, but the state doesn't have it, unless they're hiding it. And so she's claiming that, but so under the same rules of procedure of 15, you can order me an interview with the victim because she's listed on there as a witness, okay? She's the caller. So, okay, you're saying pre-trial. Trial, though.
Trial.
Oh, yeah.
If she tells-
Evidentiary hearing?
You have
Evidentiary
You have
hearing?
the right to subpoena her as a witness.
Under oath.
Yes.
Right. I don't get to call her and do it or whatever, set one up. But I can bring her, right? Under subpoena. She's my witness, too. You get what I mean? I can put, okay. So save it for that, then you're saying, right? Okay, so here's the thing. The police report, it has all their information blocked out. So how can I set up witness interviews with the information they've already given me and now they're saying, well, you had 105 days to contact them. Well, the information's blocked out. So now today, September 18th, they're declaring their Rule 15 witnesses and then and saying, oh, you've had it on the police report. Well, why, if those were the witnesses the state was calling, why wasn't there information on there so I could set up pretrial interviews? That's how it works. You don't get to put them as a witness because I have another case where all the witnesses, their name, address, telephone number, birth date is listed on there, right? And it's on me to respectfully call them and not harass them, or you get what I'm saying? Legally, hi, I'm contacting you for your interview, you know what I'm saying? That's the bounds of the conversation. Well, then why haven't I had 105 days to set up with their 15...
List today, disclosure list will have that information.
It's going to have their name and contact information, isn't it?
Are
Are they minors or not?
I'm sorry, Your Honor, what was your question?
Contact information for your...
Yes, of course, Your Honor.
Okay.
Yes, of course. Yes, of course. Why not 105 days ago? Pompous asshole. That's what he is. He's a fucking unethical prosecutor.
What is going to be to come out today is we will set deposition of the arresting officer no later than October 11th. States will make its Rule 15 disclosure today by your business today.
Sure, and just for the record, Your Honor, all disclosure has been made available.
Okay, I understand for the record.
Not the witness list. You have to do it officially, sir. You have to do it with a certificate of service. You have to file it with the court.
Make your objection. It's on the record.
For the record, all mine has to.
Then,
Evidentiary hearing, set one. Because that's what's gonna, naturally after I get this October, you have the inherent power to manage your docket. So what I'm saying is that this is the schedule. He's gonna give me my witness list today. He's gonna produce that I'm sure they're gonna wait till October 11th at the last second, but that's fine. And so then, as soon as I get those interviews, I'm gonna file a motion to suppress, and we're gonna have and I'm gonna ask for oral arguments, evidentiary hearing. So I think in the best interest of this case, for time management, case management, just go ahead and set a evidentiary hearing because I'm in the next 10 days, I'm filing as soon as first I need the interviews, right? To know what the witnesses are going to say, to know if I need to suppress it or if I need to dismiss the case based on their testimony. I haven't even had the opportunity, and you have to give me at least 20 days before trial to file my motion to dismiss and suppress and all that shit. So I'm the one that, and that prejudice is going to be argued that I've given all my disclosure months ago. They're waiting till today under court order. The crazy defendant accused of all these crimes turned over all the exculpatory evidence within fucking 4 days of being arrested. Okay, they've had all my disclosure since the first week of June. We're in the last week of September.
this event occurred.
May 20th.
Allegedly, okay, May 20th.
And May 26th. So I didn't. Okay, so
We'll go by the earlier date.
the day I got arrested for the May 20th on the 26th. You get what I'm saying?
Okay.
So, but it starts from the 20th because that's what he wrote.
Well, Rule 8 is from the arraignment date.
No, it's not. I was arraigned,
Rule 8
sir.
is from the arraignment.
Unless,
That,
sir, unless you're issued the citation and released, which I was, which could constitute my first appearance when the cop issued me the citation and let me leave. And now, if I was taken to jail, it would start from the arraignment.
Mr. Myers, you can file a motion arguing that point.
Okay. Rule 8 is
What
from
I'm
the
saying is, so we want to set a evidentiary hearing.
We can do that.
Please not October 15th, that's my birthday.
We won't do that. That's too soon after the interview.
State's,
Right, no, I'm gonna be celebrating the interview on my birthday though, that's for sure.
State's available on the 15th, Your Honor.
No, we're not doing it.
See how this dickhead just tried to get that hearing on my birthday just to play? You see what's going on, Riojas? I got him by the balls, if he even has any. These days, you never know, he might be identifying. I get it.
I'm asking.
He doesn't get to hide from the case, and then when I see him, I feel you, sir. I respect your courtroom. I want a fair trial, and I'm gonna respect you.
All right, so we want, so an evidentiary hearing, let's set it. Is October 22nd work? It's a Tuesday morning. Does that work, Mr. Myers?
I've been ready since 5 minutes after I got arrested. I was ready for trial the next day.
Let's check his officer availability.
Yeah, we know he's lying. He's
Mr.
delaying.
Myers, please.
He said 4 times he had the list though. I know he's checking. So I got a few, when he's ready to speak, when he gets his excuses ready, I'll stop. But he's had 4 times. 3 other judges have asked him all these questions, sir. And somehow I got yelled at in court and told to sit down, and he didn't get none of these. I appreciate and commend you, sir, for fucking, because none of the other judges would do it. They said, I don't want to be involved in this because I know what's going on right now.
I'm going to check officer scheduling, Your Honor.
Yeah, go ahead.
Yeah, you bet they're courting, you know what I mean? So how fair is it that the person who's innocent until proven guilty has given all the evidence to the people accusing him, but the state, under law, has the burden of proof to prove? So I could have been sitting here delaying the whole time, right? I could have been uncooperative, and we could have been here talking about how I haven't turned over anything, and you know what? That's how, like lawyers, they set the tone, right? So from the beginning, I turned my shit over. I said, here's my shit, here's, it says I got to turn this in by this day. I might be a defendant, I might talk crazy. Here's, legally though, if I'm going to represent myself, the deadlines apply to me, the court rules, you know what I'm saying? Lane Myers, pro se idiot, has met every deadline, every filing, had every argument articulated with case law from the Supreme Court. My 12-page objection of everything that was going on at the last one where it got stricken from the record because it contained the word bullshit, okay? It also contained a lot of Supreme Court case law from the state of Arizona, okay? And Court of Appeals. So let's see. I've literally said the word bullshit in here, you know, and I'm gonna tell you right now, sir, the next ones aren't gonna go like this. Because I had to put my foot down, and you did too. And now
October 22nd is a good day for an evidentiary hearing, Your Honor.
Are you available October 22nd?
I'm available any day that ends in Y, other than October 15th.
Okay, October 22nd, 9 o'clock, we're doing evidentiary.
Here.
In this courtroom.
Is it that or that, like, is it?
I don't know.
Okay. Oh, that was something not out of your control?
Yeah,
Right.
it was an equipment issue.
I thought they just put me in here so they could, I'm just fucking with you.
It was originally scheduled 14, but there was equipment issue, the recording system wasn't working.
So your normal is 14?
I know, I'm a retired judge, I don't have a normal call.
Oh, dude, hey, you're retired, so at least this one ain't gonna be boring. You're gonna get to put all them years to use. Because I'm telling you, sir, I promise you, I'll just let my argument speak from now on.
That's fine. So you have an evidentiary hearing, October 22nd at 9. So there's 3 things I'm going to order today. 1, witness list, state's witness list disclosed by close of business today. The deposition of the arresting officer no later than October 11th, and evidentiary hearing on October 22nd.
All right, so I got to say, I am very, very impressed with Lane's confidence and his skills in the courtroom. I love to see when somebody knows what they're talking about and they're confident in their delivery, like he showed right here. That's one thing that the prosecution and the judge is never prepared for. And as you can see with this, he put them in their place real fast, and I'm impressed with his skill. So this is going to be a continuing story because Lane is currently in jail without bond on an absolutely hideous retaliatory charge. Now, I had no idea who this guy was until somebody dropped his name in the comments on one of my videos. And I had to do some searching, and it wasn't hard to find. Anybody that is educated on the legal system is a complete threat to the system. And unfortunately, we see all too often retaliatory charges getting levied against that individual, things that they did not do, things that were completely twisted out of proportion. And so I'll be following this story on Lane, and I will keep you updated on the latest. This is Matthew Reardon with Patriot News Activism and We the People News. Thanks for tuning in.